Mr. Chairman, we're live.
Okay, this is your Corporations Committee meeting, and we will call the meeting to order. Matt, could you please take the roll?
Yes, thank you, Mr. Chairman. Before doing so, I'd like to briefly introduce Amber Burgess, who is an LCCC student. She's a legislative intern. She's a criminal justice major.
Welcome, welcome, Amber.
She will be helping me this afternoon. Very good. Roll call. House Corporations, Representative Brown.
Present.
Representative Locke.
Present.
Representative Heft.
Here.
Representative Johnson.
Present.
Representative Lucas.
Present.
Representative Webb.
Here.
Representative Weber.
Here.
Representative Yin.
Here.
Chairman Knapp.
Here.
You have a quorum, Mr. Chairman.
Thank you. Okay, just a couple housekeeping items. We will keep the same order as scheduled for the bills, 223, 278, 332, and 68 at the end. This is the last day for bills to be heard in the committee, and so we will keep a very tight schedule. We have a ton of people online that wish to testify. We're going to limit that testimony, and so we will begin with House Bill 223, preventing strategic lawsuits against public participation. Representative Ottman, welcome. Representative, if you could introduce yourself and let's hear about your bill.
Thank you, Mr. Chairman and committee. My name is Pepper Ottman, and I am House District Representative for 34. And with me today to help me present this bill is Colin Crossman. Okay, it is House Bill 223. And I'll begin if that's okay.
Yes, go ahead, Representative.
Thank you, Mr. Chairman. The acronym SLAPP, S-L-A-P-P, stands for Strategic Lawsuits Against Public Participation. This bill would protect First Amendment rights of Wyomingites from what has come to be known as lawfare. Specifically, the bill would specify that all the laws of our state are to be construed to grant qualified immunity to all people to protect them from strategic lawsuits intended to shut them out of the political process. In any legal action where a person is being sued for expressing their First Amendment rights, that person will have a right to seek to have the case dismissed on the grounds that it was filed to limit their First Amendment rights. And that would be their First Amendment rights to speech, but also to come together. Okay, I'll walk through the bill. Okay. Beginning on page 2, line 15, the bill states that it is the intent of the legislature to ensure full participation in matters of public importance. Moving on to page 3, the bill states that litigation that hinders constitutional rights is disfavored and should be resolved quickly. On page 3, lines 11 through 23, you will see that the bill states that all of our laws are to be construed to grant qualified immunity from legal action for people in cases impacting their First Amendment rights, and that a person can invoke this immunity at any time during a lawsuit unless the person subject to the legal action has litigated substantially in the case, in which case they will have waived their right to claim the immunity. On page 4, lines 7 through 17, it states that a person can invoke the immunity by making a motion to dismiss or otherwise dispose of the case based on the immunity granted by the act. Page 4, line 19 describes what the person must prove when claiming the immunity. The person must show that the claim against them is based on the person's use of the rights afforded under the First Amendment. Moving on to page 5, a person is entitled to the immunity if the responding party fails to present evidence to establish a case regarding each element of the claim to survive a motion to dismiss, just like how they would respond to a motion like this in any other case. Page 6, line 10. States that any denial of a motion to dismiss based on this claim can be appealed immediately. At the top of page 7, the bill provides remedies for a successful motion to dismiss, which provides a person to all costs and reasonable attorney fees for defending the case, and the same goes for the appeal. If the state or a political subdivision is responsible for the case, the government is responsible for those costs. Later on page 13, line 17, okay. The bill also provides statutory damages of no less than $10,000 to a prevailing person invoking this immunity. At the end of page 10, the bill allows for limited discovery to make the motions allowed by the act. At the bottom of page 12, the bill specifies that this immunity is available to a person to defend against administrative actions or arbitration proceedings as well. At the end of page 13, the bill also provides the ability of a Wyoming resident sued in another state to have cause of action to recover attorney fees in Wyoming if the SLAPP suit could have been brought in Wyoming. The person tried to invoke the immunity in another state, and the person prevailed in the lawsuit in the other state, but that state did not have SLAPP protections. At the bottom of page 15, the bill provides that the immunity would apply to all actions pending in the state on July 1st, 2025. Okay, there's the presentation, and you wanna- oh, this one? Okay. There is a letter, I'll just quickly go over it. On February 4th of this year, the First Amendment Lawyers Association provided a letter to leadership. First Amendment Lawyers Association, also known as the acronym FALA, a nonpartisan, nonprofit dedicated to defending First Amendment right to free speech since 1965, writes to express our support for House Bill 223, preventing strategic lawsuits against public participation. By enshrining into law this important defense against litigation designed to stifle Wyoming citizens' expressive rights, the Wyoming State Assembly can take a significant step towards protecting the fundamental constitutional rights of its constituents. Passing this law will deter expensive and ruinous lawfare against political activists, encourage media and tech companies targeted by those lawsuits to relocate in Wyoming, and bring the state in line with many neighboring states with similar protections. Looking at the particular provisions of the law, It seems that this will create a bright beacon of freedom of expression in Wyoming, which I anticipate will help Wyoming differentiate itself from other states competing for corporations to locate there. We strongly encourage the Wyoming State Assembly to pass this legislation. Please let us know if we can be of any assistance in this endeavor. Signed, Zach Greenberg, FALA President. And with that, committee, I'll stand for any questions. Mr. Crossman will be here. Did you want to make a statement? Okay.
All right. Do you have any statement you'd like to make before questions? Go ahead.
All right, thank you, Mr. Chairman. First, I want to.
And please identify
Oh, sorry,
yourself.
Colin Crossman, and I want to specify that I'm here in my personal capacity and not any other capacities which you might know me as. I do have just a couple of quick things. First, we've discussed an amendment that might or might not be brought later. This would be to clarify that throughout this law, it mentions persons, and in Wyoming law, typically that does include entities as well. But we want to make absolutely and abundantly clear that this anti-SLAPP statute applies to natural persons and entities. So not just humans, not just people, but also juristic people. And so that actually brings it to why this is a good bill for this committee to discuss, because one of our primary competing states, the state of Nevada, has what is up to now probably the country's most extensive and thorough anti-SLAPP statute. 33 states have these, by the way. We wouldn't be treading new ground here. But our primary state that we compete on for corporations, Nevada, has a law that this is based off of. They've had it for over 10 years, I believe. We have looked at their law and established this to fix some of the issues that their law has had. Specifically, this would allow Wyoming citizens to use this in federal court in a way that the Nevada statute is potentially not able to do. And we have the portability at the end, where if a Wyoming citizen, having passed this, this will make it difficult for people to engage in less than pleasant legal litigation here in Wyoming, where there's not exactly the full possibility of victory in a, call it frivolous defamation lawsuits in Wyoming. This will make that much more difficult to sustain here. So of course, then forum shopping will occur, and these lawsuits would be put in other jurisdictions. If a Wyoming citizen with this portability aspect is sued in one of those other jurisdictions, and the anti-SLAPP is either denied or not available to them, yet the Wyoming one would have worked, that individual can, upon victory in that jurisdiction over there, bring a claim in Wyoming for compensation. So in addition to protecting our citizens inside our home state, it also allows a bit of portability for actions that might be brought elsewhere. And that is particularly important to corporations that might choose to domesticate here. So with that, I'll stand for questions.
All right. Thank you. Questions from the committee? Minority Leader Ian.
Mr. Chairman, thank you, Mr. Crossman, Representative Ottman. Thanks. I actually didn't know we had this bill up this year. So I again, another great First Amendment bill. Appreciate you guys bringing it. So you would probably rank this, if we pass it as is, it'd be one of the strongest anti-SLAPP laws in the country?
Mr. Crossman.
Yes, I believe I would. Yeah, Mr. Chairman, yes, I believe I would.
Okay, follow up? Any other questions? Representative Lucas.
I know a little bit about this, but not that much, and I assume that there are people watching online and who will watch it into posterity who don't. Could you give a basic example of a type of situation that this law would be beneficial for?
Representative or Mr. Crossman?
Thank you, Mr. Chairman. An example of this would, I'll give a situation that I have some knowledge about. Let's say an individual purchased a business, and in the post of the purchasing of the business made statements in, say, the local paper, that they were going to manage this business in a manner that was better than the previous management. The previous management, potentially being a relatively wealthy individual, then sued for defamation. Well, I will run this business better is clearly a statement of opinion. There's no statement of fact in there. It's just opinion. That is absolutely protected by the First Amendment. However, in that case, if an anti-SLAPP isn't available, you would get through discovery before a motion to dismiss might be entertained by the court. Now, some courts might just grant it, but many will just say, well, let's go to discovery, especially in a state that might have judges that are maybe a bit more willing to let things go, and they don't want to dismiss things early for one reason or another. Once you're in discovery, that person who has that gigantic war chest can destroy the individual. Like, they don't have, they can spend you out. It's in a battle of attrition. So anti-SLAPPs are designed specifically to prevent that kind of situation. What they are not designed to do, and what they don't do, is if that were a meritorious lawsuit, where let's say that the statement was in fact defamation, an anti-SLAPP would not block that. Or at least if the defendant or the plaintiff could make out a prima facie case that it is defamation, the anti-SLAPP would not block that. But what this bill does do is it creates the set of requirements in the court. It creates an affirmative right, the qualified immunity, that allows for an immediate interlocutory appeal. So it's not just procedural, it's actually a substantive right that this creates. So if the qualified immunity, just like the qualified immunity, for instance, you'd have in a police case, like is same language because it's a similar concept.
All right, any other questions? Okay, thank you.
Thank you.
Appreciate it. Is there anybody here from agencies or another elected official that would like to speak on this? Elected officials first, anyone? No? Any agency or department that would like to speak on this? All right, we will move to the public. Is there anybody from the public here on this particular bill? Okay, we're saving time already. Oh, we have one. All right, members of the public, I take it you're from an organization
I
as
am.
well?
Good
Okay.
afternoon, Mr. Chairman. My name is Beth Lance. I'm here on behalf of the Wyoming Trial Lawyers Association. And I want to start by just saying we are not here for or against this legislation. In fact, our membership has a long history of supporting and protecting First Amendment rights for citizens of Wyoming. What we wanted to bring today, though, was that we do just have a few concerns with the way in which this is currently written and how that might actually look once this were to become law and what that would look like in the court system. Our first concern is on page 15, looking at lines 20 through 23. This is very broad language, and so there's just a lot of concern from our members as to what this broad language would do, saying that this applies to all actions. We understood that the bringer of the bill just explained that she wanted this to actually be applying to this specific type of public participation, First Amendment kind of lawsuits. And so when we say all actions pending in the courts, that's a little concerning. I'm not sure whether that was actually what was intended there. And additionally, then, again, using that broad term of all actions in federal courts. And then concerns here with actions in foreign jurisdictions, I would propose that that would not be appropriate for the state of Wyoming courts to be determining anything outside of the state of Wyoming. And so foreign jurisdictions would not be a jurisdiction in which our courts would be allowed to practice. So just some concerns there in how that would actually apply on the ground. Second concern with this is I did have an opportunity. I looked nationally. Certainly many states, as you heard, do have this kind of legislation. But what I read was that several states that had legislation that looks like this, which is devoid of a list of exceptions, which explains the kind of cases that this does not apply to, were actually found unconstitutional by their Supreme Courts, and their legislators had to go back and create long lists of exceptions to ensure that this could be properly applied in the court system. One example is the state of Texas, and then they went back and they did create a list of exceptions that makes it really clear what kinds of cases are actually covered under an act such as this. So those were just a couple things that we had concerns about just in the real application of the bill, but otherwise, again, support First Amendment rights.
Any questions? I had one. So just as a matter of concern with you, as would be amended on page 15, would you say to the full extent permissible to applying to public participation litigation, or is that?
Certainly that would be, make that better.
And
for
then
sure.
removing and foreign jurisdictions?
Yes, I would agree.
Okay, thank you. Just wanted to make that clear.
Yeah, I appreciate that. Thank you, Mr. Chairman.
All right. Go ahead and introduce yourself.
Thank you, Mr. Chairman, members of the committee. My name is Jessie Rubino. I'm here on behalf of the State Freedom Caucus Network. And we stand in strong support of this bill. And I just stepped in, I was in another meeting, so I don't want to rehash anything that was already said by the bill sponsor or her co-presenter. So if I do, please just cut me off. But in an era where we see ever increasing lawfare on both sides, on both sides of the political spectrum, this is a solution that we can really use in Wyoming. I think we all are familiar with many instances of lawfare dealing with major parties and also individuals in recent years. One comment that I'll make is I would caution the committee on amending the bill to only include certain kinds of actions. And my reason for this is that we see individuals all across the country being punished for engaging in protected First Amendment behaviors in the court system, in the administrative realm. We see these things all over the place. And so I would caution you on stripping out the wide-reaching protections that this bill seeks to put in place. There are hopefully some others virtually that can maybe provide some comments as to the foreign jurisdiction piece. I won't comment on that, but with that, I can stand for any questions.
Mrs. Rubino, I have one question. So there's a wide gap between all actions and I know we don't want to limit it so far that we don't include some of the others. Do you have any specific language that you would recommend there?
Mr. Chairman, I would leave the bill in that specific section as written. And the reason being, in another section of the bill, it discusses ongoing actions or other, they're not necessarily, people are not necessarily being targeted just in a lawsuit where I'm the plaintiff, I'm suing you for what you said. Someone could be targeted for protected First Amendment speech in a response to a pleading or in some other setting. And so I would leave it as is. And the reason for that is when you start listing out instances where something is protected or something is included, then you start explicitly leaving things out that you may not have intended to leave out.
All right, thank you. Any other questions from the committee? All right, thank you both. Appreciate it. All right, do we have anybody online for this particular bill?
Mr. Chairman, we have one individual online.
Okay, if you could let them in. And that would be Mr. Randazza, is that?
That's
Correct.
correct, Mr. Chairman.
Thank you.
Yes, sir.
Hello, welcome to the Corporations Committee, I understand you have some testimony on this particular bill.
Yes, thank you for the privilege of letting me provide my insight.
And please
And-
introduce yourself too.
My name is Mark John Randazza. I am an attorney licensed in Nevada, Massachusetts, Florida, Arizona, and California. I don't even know how many federal courts I'm admitted to, or state or courts of appeal, and I am admitted to the United States Supreme Court.
Please don't try to list them all.
I will not, sir. I'm a graduate of Georgetown University Law Center. I also have a degree in mass communication from the University of Florida, where I focused on media law studies. I also have a degree from the University of Torino in Italy in intellectual property law. I have spent the past 25 years and my academic career before that studying the issues inherent in this bill. I have litigated anti-SLAPP cases all across the country for about 25 years. I am not offended by Mr. Crossman's comments on the Nevada anti-SLAPP law, although I did write it. However, I must accept his criticism as it was written 10 years ago before certain developments made it clear that it did have weaknesses in it that this bill really cures. I'd like to address first some of the concerns that were raised because I think they're misplaced. The first one was the issue of at the very end of the bill saying that it applies to all actions pending in the state of Wyoming. This is information that was this appears to grow from some statutes I've seen passed like this apply only to new actions, and then others apply to pending actions. I don't know how many pending actions there are going on in Wyoming right now, but that section, my statutory analysis of that is that if there's a frivolous defamation suit that you're getting ready to file and the effective date of this is going to be announced, you might want to get it in beforehand. What this does is it discourages you from having a flood of get them in early abusive lawsuits. So that's really all that section does. Also, the issue of foreign jurisdictions, if you do a Control F here for foreign, if you search for foreign in this, it doesn't actually do anything foreign. What it does is it does allow for a Wyoming resident to apply this extraterritorially, but that's not unusual. I do a lot of cases where there's a plaintiff in one state, a defendant in another state, and then you have a long fought out battle about choice of law. I recently handled an issue like this in front of the Minnesota Court of Appeals, where we had to determine, did a Colorado plaintiff's anti-SLAPP law apply in Minnesota court, or did the Minnesota's law apply for that purpose? And all this first mention of foreign does is says that the procedural and the substantive rules in the law are severable. Now, this is an angel on the head of a pin issue that only a lawyer who's immersed in civil procedure all the time can love. But what this really means is that, let's say a Wyomingan, or I believe I'm using the wrong demonym, I was taught that before, so forgive me. But if you are from Wyoming and you get sued in Montana, and you say, well, wait a minute, Your Honor, the most appropriate thing to happen here is for the Wyoming substantive law to apply, then this law makes it clear that you're not trying to apply the procedural parts of it in Montana. So really what it does is it makes it clear what you can take with you on vacation out of Wyoming and what you can't. It doesn't actually try to do anything with respect to that court in Montana. The Montana court can still do what the Minnesota court did in my case and say, despite your arguments for this, on this particular set of facts, we're going to apply Minnesota law. The other use of foreign in this law is truly an innovation in anti-SLAPP legislation that I think gives you a very strong advantage. Frankly, if you pass this law, you're going to cost me a lot of money because my main office is in Las Vegas, and I have been beating the sheets to try to tell people to move from Delaware to Nevada. But clients who have asked me this week, should we move to Nevada? I have told them, although I'd rather you do so, if this law passes, I'm going to tell you that you need to go incorporate in Wyoming, not in Nevada, because this provision says that if you get brought to court, let's say you have a Wyoming corporation that's sued elsewhere because someone's trying to avoid the Wyoming anti-SLAPP law, and you would have prevailed had the Wyoming anti-SLAPP law applied, then you can come back to Wyoming and sue that person for reimbursement under this law. So it creates essentially a poison pill that if you want to mess with somebody, a person or a company from Wyoming, you do that at your peril if you try to forum shop into a state that doesn't have these protections. So I truly do laud that innovation. What this law does is also important as to what it doesn't do. As I am an expert in this area of law, I am frequently called to bring cases both on behalf of, say, plaintiffs in defamation cases and defendants. It does not get in the way of a legitimate case. I bring cases in Nevada all the time on behalf of defamation plaintiffs, and I will have the judges look at me and say, well, you know, you're probably going to draw an anti-SLAPP motion. And I say, I very much doubt it because I've vetted this case. It does not even create a small speed bump for a legitimate defamation case. I'd also like to address the issue raised of having perhaps a menu of laws that this applies to. And I think that is a very short-sighted decision if you were to change that, because plaintiffs' attorneys who are, you know, I'll give you, when somebody comes to an attorney and says, I want to shut this person up from criticizing me, or I want to stop these people from protesting, that person's money is going to create a lot of creativity. And I will give you an example of a case where I represented a consumer review website. You're all probably familiar with Yelp. Yelp was not in this case. I just bring them as an example. And a dental clinic had a number of negative reviews on it, and they wanted those reviews down. Now, the review site didn't put them up, and the review site is immune from liability. But nevertheless, they sued them because they said, maybe we can just make this expensive enough for you that you'd rather take down these reviews than allow them to remain there. Now, had they succumbed to that, that would have hurt not only their free speech rights, but it would have hurt consumers' rights to make an informed decision. But one creative thing that that company did is they sued also under an unfair competition theory. And I've seen that happen a lot of times. I had another client that had the same exact thing. Two dueling neurologists who were debating an issue of whether a certain cure for treatment for Alzheimer's disease was, the statement my client made was, these claims are leaps and bounds ahead of the evidence. And the other doctor who was trying to sell his services sued him for unfair competition, saying that my client was competing with him, and that's why he made that statement. And meanwhile, my client was just a research scientist who didn't see patients. But if you enumerate which laws this applies to, you're going to find creative, censorship-minded people and organizations that find a way to evade it. This is written in a way that makes perfect sense, and it gives the greatest possible protection for freedom of expression. I will be upset if you pass it because I'm not a Wyoming lawyer. My law will no longer be the beacon of the best anti-SLAPP law in America. And I'll just have to settle for that silver medal. And I'll have to tell my clients, you should go reincorporate in Wyoming unless Nevada gets its act together and competes with you. But you'll be in first place with this. And I urge you to take that gold medal and not let it go.
Well, thank you. I think you've answered a lot of the questions that the committee would have. And thank you for your economic development to our LLCs as well. Are there any questions from the committee? Minority Leader Yin?
Mr. Chairman, thank you. Mr. Randazza, you surprisingly convinced me to keep the applicability section. I think I was in favor of removing it, but your argument was very thorough, and I appreciate that. So the one thing I am still concerned about is that we do have a couple of very smart attorneys in our legislature, and I don't want the retroactiveness of the pending action to risk passage of the bill. One thing that we do in Wyoming sometimes is make our acts effective immediately. So on passage and signage, we could make it effective immediately. Do you think that would be okay if we made it effective immediately and then remove the pending word on there and the date on the applicability section?
Mr.
Yes.
Randazza?
Yes, I think that would take care of the problem.
Okay, thank you.
Thank you, Mr. Chairman.
Any other questions from the committee? All right, thank you for testifying today. We appreciate it.
It's my pleasure. Thank you for having me.
Hopefully they'll allow you to stay in Nevada. Okay, any other public testimony? I'm going to close public testimony. Committee, what's your pleasure? Moved by Minority Leader Yin, seconded by Representative Lucas. Are there any amendments?
Mr. Chairman,
Yes, Minority Leader Yin.
we got some amendment that was handed to us. I don't know who that was from. So does someone want to claim it? Oh, okay. So then I'll make my amendment first and then have Representative Lucas talk about her amendment.
All right, go ahead.
So, Mr. Chairman, on page 15, I would strike the word pending on line 20, and then on line 21, strike on July 1st, 2025. And then on page 16, change section 2 to effective immediately.
All right.
Needs to be seconded for
moment.
discussion.
So we have a motion and a second on that amendment. Matt, did you catch both of those factors to the amendment?
Mr. Chairman, I did not. Representative Ian, if I could get you to repeat the amendment at the bottom of page 15.
Mr. Chairman, on line 20, page 15, strike the word pending. And on line 21, strike on July 1st, 2025. And then on page 16, again, effective immediately.
All right, do we have that clear? Thank you. Any discussion on the amendment? Representative Lucas?
Thank you, Mr. Chairman. Minority Leader Yin, great. But I was wondering if we were keeping on page 15, line 22 pending as well?
Representative?
Mr. Chairman, I think it would be appropriate to strike that as well on line 22.
Would the second confirm to include that in the amendment? All right, any other discussion? All those in favor of the amendment, please signify by saying aye. Aye. All those opposed, no. That amendment does carry. Do we have any other amendments? Representative Lucas?
Thank you, Mr. Chairman. Let me just get to the right place here. Thank you. So the page 2, the short title section, so definitions and purposes, we have A, B, and then Romanet 1 and 2, this amendment would add Romanet 3, which would be person, where used in this act, shall include groups of individuals, associations, corporations, and other entities. This amendment was provided by the bringer.
All right, thank you. Is there a second? Second. We have a motion and a second for that amendment as presented.
Mr. Chairman?
Is there any discussion?
Yeah, could I bring up Mr. Crossman and ask him about it real quick, if that's appropriate?
Absolutely. Mr. Crossman, if you could come answer to this?
So, Mr. Chairman, Mr. Crossman, our LLC law refers to Title VIII, which is our rules of statutory construction, and has a definition of person in it as well. If we add this definition, it would make it so it wouldn't be the exact same as the definition in Title VIII. Do you think we need this?
Mr. Crossman?
Yes, Mr. Chairman, this is a belt and suspenders to make sure that this isn't construed to only apply to natural persons. Perhaps what was the citation that you just gave me? If I could get that again.
So, Mr. Chairman, I was saying that our LLC Act refers to the Title VIII definition. So Title VIII is our general provisions title. And so it's like common law and rules of statutory construction. So it has a definition of person. And that person includes individual, partnership, corporation, joint stock company, or other associations or entity, public or private. And so if we don't have a definition of person, it will fall back on that Title VIII definition.
Mr. Crossman?
Yes, Mr. Chairman, it might be better than for this to just refer to explicitly state that person for the purposes of this refers to the Title VIII definition rather than enumerate its own list. That might be a better way to go. However, if the group believes that it should be just stricken, I guess that would be fine too. But I think that the point of having that explicitly inside this statute would be to make sure that the courts don't attempt to route around it.
Yeah, I think it's a good idea to stand it up, but reference already existing statute, so. Anything else on that?
So, Mr. Chairman, just to offer as a friendly amendment, can we change this amendment to refer to that Title VIII definition?
Representative Lucas? Is a second in compliance with that also? I think, was it? Are you okay with that? Okay. Yes, so if you could get that cross-reference, Matt, as that amendment?
Matt, it is WS 8-1-102 AVI.
Mr. Chairman, just to confirm, Wyoming Statute 8-1-102A, Romanet 6.
That's correct.
Very good, thank you.
All right, thank you. All those in favor of that amendment, please signify by saying aye.
Aye.
All those opposed? That amendment carries. Is there any other amendment for this bill? All right, would you please poll the committee?
Thank you, Mr. Chairman. This is a roll call vote for House Bill 223, preventing strategic lawsuits against public participation. Representative Brown?
Aye.
Representative Locke?
Aye.
Representative Heft?
Aye.
Representative Johnson?
Aye.
Representative Lucas?
Aye.
Representative Webb?
Aye.
Representative Weber?
Aye.
Representative Yin?
Aye.
Chairman Knapp?
Aye.
Chairman, 9 ayes.
With that, House Bill 223 does pass the committee. All right, next up, House Bill 278. And we have our own vice chair and chairman, Representative Locke.
Thank you very much, Chairman, and I'll go through this as quickly as I can. I know we have a long list of things to work through. So House Bill 278, elections, voting machine, and voting system tests. This is an attempt to basically put some additional some additional strength into some of our testing requirements is what this bill does. And so moving ahead, you'll see, as you get down to the bottom, you'll see that we're going to have some amendments to sections 2210, 108, 10, 10, 110, 2211, 103, 2211, 104. And there will be amendments to those sections. Moving ahead, starting in section 2210, 108, at the bottom of page 1, moving over to page 2 fairly quickly. We basically add in some text here. Before preparing a voting machine for an election, the county clerk shall, not later than 5 days before a test on a voting machine, or not later than 24 hours before a retest of the voting machine, posted public notice. So here we're just adding in some guidelines to make sure notices are done in advance far enough. There was some discussion on this on what was the right amount of time, trying to put that 5 days in. But for retests, we realize we've got to do that fairly tight timeline. And you're going to see this again as we move forward. Moving down, you'll see that there was some language down there on lines 10 through lines 12. There was some language in there about political party representatives, and that's been changed just to members of the public, just to make it more general, making it available for people to get to view the testing. Same thing as you move down to line 17 again. The county clerk in the presence of these representatives is what it was before. Representatives is struck and attendees is put in place. Again, just more generally trying to make it available to the public. Moving over to page 3, paragraph B, starting on line 9. Again, the inspection of the voting machines may, there's a shall put in there, not less than 2 weeks before the elections and continue until all machines to be used are publicly tested and sealed. So they're just trying to, we're just trying to put some strong guidelines. Again, it's not less than 2 weeks in advance. Obviously, the local clerks will decide what is most appropriate for them to do, but the objective here is to make sure we give enough time to make sure these tests can be done. Moving down to the bottom of that page, line 22 and 20, or 21 and 22. This is just talking about the testing certification, and it was added in that this certification shall be filed with the Secretary of State, and a copy shall be kept on file in the office of the county clerk. So the line added in there was just that a copy will be filed with the Secretary of State, and a copy shall be held. Again, moving on to page 4, and again, I'll try to be as quick as I can. Paragraph C was added in. No voting machine shall be used in any election unless the machine is tested and prepared in accordance with this section. So again, we're just giving some guidance here. Moving into the next section, 2210, 110. There's some language struck on page 9 and 10. You'll see that shall be a voting machine prepared for an election and certified by the county clerk, and it struck that language, shall be conclusively presumed to be properly prepared unless within 2 days. That's all been struck. And it says may be challenged after the machine is sealed and before the election if a complaint is filed in the district court of the county stating the number of the machine and the grounds for objection to its use. So just a change to that language a little bit. Moving on to page 5, and I'll try to speed this up a little bit. There's just some language added into line 3 there. Testing in and was inserted. Moving down to the bottom of page 5. This is that language before, not later than 5 days before the test of an electronic voting system, or not later than 24 hours before a retest. And again, the posting of the public notice. And again, page 6. Here we talk about, you'll remember on that earlier on, The political party and representatives were mentioned. That is all struck here, and members of the public, all automatic. There's when you get to lines 6 through 6 and through line 9, it talks a little bit, a test shall ascertain that all automatic tabulating equipment to be used in the election will accurately count the votes cast on all ballot styles that may be used in the election. So just some changes to the words to make sure it's very crystal clear that any ballot styles that are used and all automated tabulating systems will be tested. Moving on down, one of the things that was added in here, there was a discussion on this paper ballots or ballot cards is struck, and it was just simplified to all ballot styles there in lines 11 and 12, 17 through 22. There's some text added in. If the primary method of voting in the county is an electronic ballot marking device, now it's my understanding this may only exist in one county. I may be wrong about that, but that's my understanding. So there was some language put in to make sure this was clear. If the primary method of voting in the county is an electronic ballot marking device, the test shall be conducted using ballots or ballot cards that are marked by the electronic ballot marking device. It's just trying to be crystal clear that these systems that mark the ballots, these electronic mark the ballots, those will be tested as well. Okay, and then when you move down from that, lines 22, it talks a little bit about, and we start to put in a few kind of clear items that we want to make sure are tested. And you'll see on lines 22, including write-in candidates, we want to make sure testing for write-in candidates is done for an office, and for and against each measure, including at least one undervote and one overvote in each race or measure each precinct in each county. So here we're starting to put some more, a little bit of detail on some areas that we want to make sure get tested. Now, not a lot of detail here because I think ultimately more detailed promulgation of rules will be put in place, but there was some thinking that some of these concepts needed to make sure they were in here and covered. And then moving ahead, if any error, and I'm on line 2 of page 7, and I'm sorry I'm going so fast, but I'm trying to make sure we get through this quickly. If any error is detected, or if the test is not completed in compliance with the law, the cause of it shall be ascertained and corrected, and an errorless count shall be secured and certified by the county clerk. On completion of the count, the results shall be retained by the county clerk, posted on the county clerk's website, and then provided to any person upon request. And then you'll see there's some additional language added on lines 11 through 14. Provided that if a retest is required, the seals may be broken so that an errorless count can be secured and certified as provided in this paragraph. So I know I went fairly quickly. Really, these changes aren't earth-shattering. Is all of it has happened in here. There's been a few changes to specific wording, adding in a few, I would say, clarification to make sure it's clear, exactly what the guidance to the clerks will be when it comes to the testing process. But I would say none of it is really all that significant in change other than enhancing the clarification. So I'll stand for questions.
Mr. Vice Chair, excellent presentation. Are there any questions from the committee? All right, thank you. I would like to bring in, I think there's two representatives from the Secretary of State's office. Is there anybody here from Secretary of State's office? Oh, hey, how are you? Let's come up and have your testimony on this. Please introduce yourself. Good morning, or afternoon.
Good afternoon, Mr. Chairman. Jesse Naaman, Deputy Secretary of State. Joe Rubino, our Chief Policy Officer and Counsel, is online. If you're prepared to take his testimony right now, he's the one from our office who's going to delve into the weeds if...
All right, yes, let's let him in.
Hey, Mr. Chairman, can you hear me?
Yes, Mr. Urbino, and just as a saving of time factor, if the Clerks Association can come up as well. I know you have some amendments, and I'd kind of like to get your opinion and go through those amendments first and then move to Mr. Urbino.
And Mr. Chairman, really quick, the secretary is actually on. We didn't know if it would be either me or him because we're testifying in a couple of different meetings right now. So he's actually on, and I'll just defer to him if he could be added.
Okay, thank you, Mr. Urbino. Hi, go ahead and introduce yourself, and we'll go ahead with the clerk's testimony first, and then look at some of your proposed amendments, and then we'll go to the secretary.
Okay. Thank you, Mr. Chairman. Good afternoon, Mr. Chairman and members of the committee. I'm Mary Langford, and I have the honor of representing the county clerks of the state of Wyoming. Joining me today on Zoom would be the Honorable Julie Fries, the Fremont County Clerk. She'll be providing some testimony also.
Okay, let's go ahead and let her in as well. Is it okay if you scoot over, Mr. Secretary, so Ms. Freeze can be beside you?
Always.
All right, thank you.
Thank you.
Looks like he's in a bouncy chair, huh? Mr. Chairman, our purpose today is to focus on the administration of Wyoming elections and the testing of machines and systems. This bill provides for posting public notice and clarifying that testing is done before the public. And with that, I want to hand off to the Honorable Julie Fries from the Fremont County Clerk, who we've got on TV.
Ms. Freeze, can you identify yourself and welcome?
Thank you. Good to see you again after an early morning this morning. Julie Fries, Fremont County Clerk, representing the County Clerks Association of Wyoming. So a couple of things that I did over the last several days here is I asked the county clerks to I'm just giving you information. I asked them to give me some of their testing methods, and I just want to report back that every voting machine was tested in this last election. A majority of the folks ran at least every ballot style through the machine, including your express vote and the BODs. And some of them even made more of those or did a full test deck on the express votes and the regular machines. Some of them, like I said, did run the entire test deck. Some of them did do some sort of a hand counting or audit while they were doing their testing, either with the public or prior to that. And so I just wanted to let you know, I know there's been a lot of conversation over the last several days about maybe our failure to do our job. And I just wanted to let you know that I wanted to know what that was like. And I know there's some amendments that Mary has for you, but I just have a couple questions. If we do have a situation, I'm going to bring up Weston, bless them, because of their issues. So they found a problem late that there is a ballot problem. I don't see anywhere here if I only have 2 weeks to do something. So what happens if in the last 8 days, I find an error after I tested and now I need to fix my ballot and I need to retest? I'm not sure if I see that in there. And if Mary, if you thought of that as well, I just want to make sure that we don't screw up and we'd have time to do a retest. Because I think that's super important from everything we've learned over the last election, that would have helped maybe I don't know if they did, I'm sure they did some kind of a test on that, but I would want to make sure we would want to have the ability to retest. And my only question is on page 5, not that it's a big deal, but is there a reason we have to notify the state chairman? We always notify our county chairman way early in the process that we're going to need people to come and help with our testing. Personally, as a county clerk, I like people there testing, so they ask questions, they learn, and a lot of them leave with, wow, I didn't realize, there was a lot to this and it was very interesting. So those are some of the questions I have, and I'll stand for questions now or even after Mary talks. I think the only last one too she may have is on page 7, the express vote. We can't overvote on that, which is a great reason we have that machine. So we wouldn't be able to get an overvote on that, but we would get on our expected outcomes from all the other ballots. We certainly can do at least, and probably way more, undervotes and some overvotes. And we're thankful that they don't have to be different than the candidates in the write-ins. So thank you.
All right. Thank you very much. Are there any questions for Ms. Fries? Okay, thank you so much. Ms. Langford. So in addition to your proposed amendments, would you care to answer about the 2-week, if a ballot had to be changed, that time frame?
Oh, that time frame and how short it would be.
Yes, ma'am.
I don't have anything proposed for an amendment to that, but surely we would need to have an amendment to address that situation because it can get that tight.
Thank you. All right, can you go through your other proposed amendments?
Yes, sir, I can. On page 3, begins with line 21 and 22 in that area where there's already a change there. We'd like to change that to send, the original should come to the county, the original certificate should come to the county, and a copy to the Secretary of State. Reason being is the county owns the equipment. We'd be happy to share a copy with that certificate. That's a minor issue. On line 20 of that page 3, is where you would insert the copy and then the certificate. That's pretty self-explanatory. On page 5, line 23, again, and Julie mentioned this before, the county chairman should be sending that notice to the state chairman. And so to strike the state chairman out from that section. On page 7, we'd like to suggest on line 2, where it says that each precinct, change that to each ballot style. And then at the end of that sentence, include if possible. Then on line 2, and the reason why the if possible is because if it's possible, it's not possible to overvote on an express vote. So you would never have any overvotes. It doesn't allow you to do that. Otherwise, we really don't have any issues with the concept of this bill. And basically, it requires public knows and provides more clarity for the testing, that it be open to the public.
Any questions for Ms. Langford? Representative Lucas?
Thank you, Mr. Chairman. Ms. Langford, good to see you again.
Hi.
I see you a lot here. That's great. What's an express vote?
Express vote is the automatic marking machine. So it's the touchscreen that's required to be in every polling place to accommodate the handicapped community. And then in Laramie County, they're exclusively used for their voting. So it's a automatic marking machine.
Follow up?
So if I'm understanding, then it's not possible to overvote on those machines.
That's correct.
Okay, thank you.
Thank you. Minority Leader Yin?
Madam Chairman, thank you. Ms. Langford, and maybe a question for the Secretary of State's office. So on page 4, that new section C, so we're talking about that timeline and trying to see if there's ways for us to accommodate if there are any issues in those last 2 weeks. Could we add at the end of line 4, unless authorized by the Secretary of State? Would that allow for an exception there?
Ms. Langford?
I'm going to defer to the Secretary of State.
Okay, I think we'll ask that when we bring him on. I had one question. So on page 7, line 2, is there another alternative for if possible? I think that might leave it too open. Would it be okay to say for those counties with potential undervotes?
Yes.
Is that all right? Okay, I'll just log that as, yes, Representative Lucas.
Thank you, Mr. Chairman. I was wondering if instead of if possible, we could put in something like for each machine type capable of having overvotes.
Very similar.
I know.
Mr. Chairman, we'd be happy with that too.
All right, all right. Let's bring Chuck back on screen here. Secretary Gray? Secretary Gray,
Hello.
thank you. If you can identify yourself and then address the potential amendments from the clerks and your own comments. Thank you.
Thank you, Mr. Chairman. Is it okay if I do the comments first before the amendments?
Absolutely.
Thank you, Mr. Chairman. Mr. Chairman, committee, the impetus for this bill is really about ensuring clarity and rigor in the public testing of our voting equipment prior to elections. I'm fully in support of House Bill 278. As a little bit of background and at a high level, Wyoming law currently requires the testing of voting machines prior to an election to run a predetermined number of ballots through our voting equipment to make sure the equipment is tabulating our votes accurately. And one of the key requirements in this process is outlined in 22-11-104B Roman 3 is the requirement that during the test, quote, a different number of valid votes shall be assigned to each candidate for an office and for and against each measure. And this requirement isn't just a formality, it's crucial to ensuring that the electronic voting machines are accurately counting and tabulating the votes for each candidate when the actual ballots are tabulated on election night. However, during the 2024 election cycle, specifically prior to the 2024 primary election, there were issues that were brought to our attention that some tests did not assign a different number of votes to each candidate as required by 22-11-104. In response to these concerns, I sent a letter asking the counties to retest their voting equipment to comply with 22-11-104, and 19 of the 21 that had issues on some portion of their test deck did retest their equipment prior to the 2024 election. And however, through the numerous discussions that we had with both the clerks as well as members of the public, there were a number of questions raised concerning the testing of voting machines, specifically with respect to the following issues. One, the timing of the logic and accuracy test and the ability to retest. So in answer to Clerk Freeze's question on page 7, and we'll get to this when we talk about the amendments, there's a very clear statement that a retest can be done to modify an error at any time. And that was one of the things that the two counties that did not retest contested a little bit, which, you know, in my opinion was unfortunate. But we make that very clear in that provision on page 7, in my opinion. If we want to make it clear, that's fine. But that's what we're trying to do there. Two, the ability of the public to attend the testing and the posting of notice to the public for testing. And that gets a little bit, I know I'm going to get to the amendments explicitly, but I am opposed to that state chairman amendment, taking the state chairman out. I believe that it's a backup. There was a county where the county chairman claimed that the clerk wasn't sending the notice to the right email. Even after he clarified that, I want to be clear, this is statements back and forth, but so I don't have all the emails in front of me, but this is one of the things that we're dealing with here. And I think it would just be better to get more eyes on the testing notice and sending it to the state chairman. I don't see any downside to that. And then 3, one of the other things this bill does is clearly assign a different number of votes to candidates under both the title and the spirit of the law to ensure the equipment is counting votes accurately. And so I really appreciate the sponsor of this bill taking this issue on, listening to the concerns that are out there, and trying to achieve clarity in our statutes governing the testing of voting equipment prior to elections, and then also ramping up the rigor. That's really the two things we're doing here. One of the things, too, is addressing the direct issue and questions received in the 24 primary. It provides that write-in candidates are treated like other candidates for purposes of assigning a different number of votes to test the machine's ability to accurately count votes. And we want to maintain that in here, providing that every single machine should be tested that is to be used in an election, not just every type of machine. That was another one of the colloquies we had with the clerks, and our position was always that it should be every machine, but this makes it clear. Clearing up inconsistencies concerning timing of tests and the ability to retest, and providing that a list of the equipment tested is available to the public. Now, on the amendments, I truly believe on page 7 that the retest, I have that language here, but I think, on page 7, it's the last thing there. Provided that if a retest is required, the seals may be broken so that an errorless count can be secured and certified as provided in this paragraph. And that was the issue, was the argument was that, you know, the sticks were in the bag and sealed, and so they couldn't unseal it. And so I think that that makes it clear, but if we need more clarity, I'm all for that. The one of the big overall intents of the bill is achieving clarity on the ability to retest at any time prior to the election if an error is found. Um, in terms of the clerks sending us a copy of the certificate rather than us getting the original, I think that's fine as long as that is indeed what the amendment does. I'm not there, but I'm just tracking it in here as I'm getting it verbally, and I think that's what that one does. And as long as they send us something that is sort of a attestation, an affidavit, if you will, that this has been done properly, that is very important to us, that there is something that is coming to us on that. And then I got an amendment on state chairman notification. I'm opposed to that. I think I'm opposed to taking that out. I think we should keep the state chairman in. It's just another set of eyes when there's miscommunications or who knows what happens. And so I think that's an important thing to keep in the bill. Was there anything about undervotes? I was trying
That
to.
was on page 7. Yeah, I'd like your opinion on that, so that we get rid of the language that was proposed of, if possible, to narrow that down to a county that would have potential undervotes.
So they delete the first two lines of page 7.
No, it's proposed change to overvote in each race or measure in each ballot style precinct and in each county if possible, but I think if possible is a little too vague. So if you're okay with language that identifies a machine that could have the possibility of doing an undervote.
You know, could we bring in Mr. Rubino on this one?
Mr. Urbino, are you still on?
Yes, Mr. Chairman, can you hear me?
Yes.
I believe that this could be accomplished on page 7, line 2, after each precinct and in each county, if you added for each type of electronic voting system capable of producing an overvote.
Okay, thank you.
Yeah, and in response to, sorry, in response to Representative Lucas's question, the express votes are the machines where you know, it's not an oval. The barcodes are casting the vote, which we've always been concerned by outside of the provisions of it being required under federal law, but for disabilities and situations like that. But that's kind of a separate issue whether we use them or not. We just want to make sure they're tested as well in both parts of the process on those, because they have two parts of the process. You have to test the ballot marking, that the ballot indeed spits out what you marked, and then you also have to test that the barcode is matching what the name is under it. And so that's the two things that, and it's two separate. That's part of the issue with the express votes. There's two things you're testing on the express votes. You know, two separate parts of that process, I guess I would say.
All right. Thank you for your testimony. I think we're going to move on to public testimony. Oh, I'm sorry, Representative Yen, do you have a
So,
question?
Mr. Chairman, I wanted to ask if the Secretary of State had that opinion on that 2-week timeline, and if we gave him the authorization to allow fixes in between.
Mr. Secretary?
Yeah, Mr. Chairman, I think that that would be fine if we have the ability to say it's okay. I mean, that's okay. I think page 7 kind of already does that. Um, but if you want to have sort of an explicit thing on the 2-week period, but I read that on page 7, but I'm fine if that further codifies it.
All right, Minority Leader Yen, does that answer your question? All right. All right, thank you very much. Moving on to anybody else in the room who has come to testify on this. Okay, Ms. Langford, I'm sorry. We have a quick question from Representative Lucas. If you can, yes or no this?
Mr. Chairman.
Representative Lucas.
Thank you, Mr. Chairman. Ms. Langford, in the event that a machine has to be unsealed and then retested, would your procedure then be to reseal the machine?
Yes,
Ms.
ma'am.
Langford,
It would be,
And your seals are numbered?
yes.
And do you have a
through the
log?
chair, please.
Oh, I'm sorry, sir. Mr. Chairman,
Yes, Representative Lucas.
thank you. And then, do you have a log that you record, you keep track of the seals that are used?
Ms. Langford?
Mr. Chairman, yes, they're seals, they're numbered, they are logged, and then they're checked.
Thank you, I feel good.
All right, thank you. Thank you, Ms. Langford. All right. Mr. Shuck, if you could identify yourself for the record?
There we go. Okay, thank you. Thank you, Mr. Chairman. My name is Brian Shuck. I serve as general counsel for the Wyoming Republican Party. And during the course of the testing for the primary and the general elections in 2024, we ended up learning more about election testing than we ever cared to learn. And so we wanted to share some of those experiences with you today because that gives context to kind of why this bill is coming now. The 30,000-foot view of this bill is that really it's designed to provide two things: clarity on exactly what needs to be tested and who's to be provided notice, and transparency all throughout the process so that the public can feel comfortable that their elections are safe and secure. So something that will help you as you're working through this bill is to understand that there are election machines, which are referred to in 22-10, and that chapter deals only with machines. And Representative Lucas was asking about the express vote machines, and that's what they're referring to there. Those are the express vote machines. Those are touch screens that record our votes. Here in Laramie County, we all have to use those machines. But in all of the other 22 counties, they're used primarily for those people who either specifically asked to use them or for disabled people who need help voting. And I've talked to election judges who have served for many, many years, and they tell me that in the other 22 counties, they very rarely see people use those machines. So there's kind of that difference between how one county and the others do it. So 22-11 deals with voting systems. And so when you see the word voting systems in 22-11, think tabulators. The tabulators is that big box at the end of the process where you feed it into the machine, and that's accepting and counting your ballots. And so that's the difference between the two. And because of that, some of these provisions kind of need to appear in both places for both the voting machines and the tabulators, which is why I'm recommending an amendment that I've handed out, and I printed out a copy of that so that it's easier for you to see what the amendment looks like. But as to the amendments that some of the other folks introduced, I think a lot of the clerk's amendments would be fine. As far as sending notice to the state chair, that's very important. We had one county in particular where notice was allegedly sent to the county chair at an email address that the clerk was told not to use. And because there were problems with using that email, then the party did not get notice, and the party did not have an opportunity to participate in that testing. So by having both county and state chairs notified, then that should fix that problem. On page 7, line 2, the clerks had also suggested deleting the word precinct and putting in the word ballot style. In that particular place, that word precinct needs to remain there. Ballot style doesn't belong there. What we're asking for in this bill is to make sure that they test the overvotes and the undervotes in every precinct. And when the tests are done, the way this, if that precinct word is deleted, then they can test for one undervote in one of the precincts and then not test in any of the others. And one of the most important things that we learned that we found out was not happening well in a lot of the counties was that there were 0 votes assigned to undervotes and overvotes. That was one of the issues we routinely saw. And it's really important that there be a whole number assigned to those, and a 1 is just fine. But if there's a 0 assigned, how do you know if the machine correctly counted 0 votes or it didn't count any votes? So either way, that's going to result in the 0. So that's why zeros can't be there. The Wyoming Republican Party engaged an expert to help us learn this whole process, learn the gold standard in terms of testing. Our expert testifies routinely in a number of other states. In fact, I had hoped he was going to be on today online, but he's tied up in South Dakota in their legislature and wasn't able to join us today. But so we'd recommend you leave the word precinct. In page 7, line 2, I also agree that the words "if possible" are just too loose. I like Joe Rubino's proposed edit. I think that probably fixes it. One other thing I would add that I think is really important in this process is to understand that different ballots are counted completely differently. For the express votes that we were talking about, when you touch the screen and you vote for whoever you're going to vote for, then on the ballot card that it spits out, it has a barcode on there.
Mr. Shuck, just to cut you short a little bit, I apologize, but we did have another bill that everybody's familiar with that style. I'm going to, if you're done with your proposed amendments, I'm going to move on
Yep.
to,
No, I think that's good.
okay, thank you, sorry about that.
Thank you, that's right.
All right, in about 2 minutes or less, introduce yourself and whether you support or oppose the bill.
Great, thank you, Mr. Chairman Knapp. My name is Jill Kaufman. I'm from Platte County. I represent Platte County Integrity Group, and I am absolutely in support of this bill. I am very pleased to see this and working with the clerks on getting this detail figured out. One little clarification, I agree with everything Mr. Shuck here has said. One little clarification that also needs to be tested on these HAVA vote machines, which is the express votes, is you need to test for the hearing. You need to test the little, it's a little keypad, the up and down buttons and everything. And also when you listen to it, you need to make sure that it's in English or whatever the targeted language is supposed to be, because there's been some accidents with that. So those are only my things. I truly support this bill. Thank you.
I appreciate that because those machines are going to be in existence for that very factor of complying with HAVA and making sure that those are operating correctly. So thank you.
Absolutely. And Mr. Chair, I do believe HAVA has guidelines on how to test those as well.
All right, thank you very much, I appreciate it. Okay, is there, I know there's testimony online. Unfortunately, was there anybody for this?
Mr. Chairman, we have 2 more individuals online. Marissa Carpio with the Equality State Policy Center and Karen Rimmer from Converse County.
Okay, my apologies to those that are testifying online, but in the sake of time, just to finish this bill and get back to the floor for budget amendments, I'm going to move on. Okay. Anybody else in the room to testify on this? I will close public testimony. Committee, what's your pleasure?
Make a motion, we move the bill.
Okay, Representative Brown with the motion to move and Representative Weber with the second. All right, let's go through the bill. Do I have any amendments from the committee? Page 1, page 2, page 3. Yes.
Are we going to accept these
It-
group or one page at a time?
Let's do one page at a time because we had some differing language on differing proposed amendments. So if you want to make an amendment on page 3, we're open to it.
Okay.
If you would like to include Ms. Langford's in your amendment, you can include it. Okay, can you go ahead and state your amendment?
Thank you, Mr. Chairman. Old dogs learn slow. At the bottom of page 3, one of the amendments requested was at the end of line 20, a copy of should be inserted before this. And then it would read, certificate shall be filed with the Secretary of State, and then a copy on line 22 at the very beginning should be struck, and the certificate shall be kept on file in the office of the county clerk. I don't see any problem at all with having the Secretary of State get a copy of the certificate, and I think the certificate, the original certificate, should remain with the clerk.
All right. And for the sake of time, I'd like to leave your amendment open as we go through each page, all right? Page 4.
Before we leave page 3, on page 3, line 12, after sealed, insert a new sentence. Sealing of machines does not prevent the clerk from breaking the seal to print or report.
It's on. Bring your mic closer to your. Bring it closer to you.
Okay.
Go ahead and start that sentence again.
Okay, so after sealed on line 3, or in page 3, line 12, insert the sentence, sealing of machines does not prevent the clerk from breaking the seal to print or report or data request by the public, the Secretary of State, or the court, and then resealing the machines.
And I think the word right out after print is.
Print.
Print out.
Okay.
All right, Representative Lucas, is that okay to add to your amendment? All right. Page 4. Anything on page 4? I know we're building a monster amendment, but for the sake of time, that's what we're doing. Nothing on page 4? Okay, page 5.
Mr. Chairman, I would like to strike out the state chair because I don't think my state chair needs it. But if it's something that y'all state chair needs, then feel free to vote against it.
Okay. Representative Lucas, do you want to add that into your amendment or not? If not, we'll treat it as a separate amendment.
Mr. Chairman, do you mean removing the state chair?
Yeah, at the bottom of page 5, line 23, state chairman and the
Yeah.
county chair.
I really think that it could be useful to include the state chair. It certainly doesn't harm anything. And I'd like to keep that in.
Okay, I think testimony is, it gets there regardless, but it doesn't hurt to have it backed up in statute. Okay. Page 6. Page 7.
Would it, Mr. Chairman?
Representative Brown.
For these amendments that we have to make that Mr. Shuck gave us, our clerk has that over there. Could we just ask him to put those in the way they are, or do we have to state them?
Representative Lucas, I'm going to treat this as your amendment still. And so whatever language that you would like to add, whether it's from Mr. Shuck's page or any other, please just let us know what your amendment would be.
Thank you. Thank you, Mr. Chairman. Well, the one that Representative Brown had just voiced a moment ago is from Mr. Shuck's recommendation, and that's on page 3, line 12. That's great.
Well, we're all the way to page 7 now, so
No, I know. I'm just kind of catching up here. I agree with all of these, actually. Oh,
yep,
shall I read them in?
go ahead and read those in.
Okay,
Yeah.
thank you. On page 7, line 7, delete the word results and insert detailed reports by precinct, comma, complete audit logs, comma, and proof of testing.
All right, and then anything above that on page 7, maybe around line 2?
He doesn't have anything on line 2.
Oh, I'm sorry.
On the printed paper we got. On page 7, line 12, after the word required, insert or complete audit logs, proof of testing, or general or detailed test results are requested. And I know that the clerks do that, so it shouldn't be hard. Line 7, on page 7, line 18, Council, Mr. Shuck is suggesting that we delete July 1st, 2025 and insert immediately. And I like that too.
Is that all right?
Mr. Chairman, and then I believe that one of the other things was in that line 2 was the wording proposed by Mr. Rubino.
Correct. Would that be okay to include in your amendment? Okay, so Matt, are you clear with all of this? So that last part of that amendment was on page 7, line 2, to include Mr. Rubino's language.
Yes, Mr. Chairman, just for clarification, page 7, line 2, there was a proposal to include the term ballot style between each and precinct. So this new amendment would reverse that. Is that correct? We would just leave it.
Leave it as
wording
precinct.
Each precinct?
Yes.
Okay. My only other question was the language that we added, page 7, line 2, after county insert, it was, the original amendment was if possible. I just want to see whether that language proposed by Mr. Rubino was acceptable as well, and if so, I'd like to make sure I've got that.
Representative Lucas?
Yeah, not accepting if possible. And then I'm going to say it kind of how he said it because I wrote it down, but I'm not sure I got it exactly, but I think you did. For each machine type capable of having overvotes would be inserted at the end of that sentence instead of if possible.
Again, clarification for each machine type capable of recording overvotes.
Even better.
Okay.
All right. Is the committee okay with that amendment?
Mr. Chairman.
Yes, Minority Leader Yin.
The only thing I would suggest is that on the printed out copy, the page 7, line 7 version says detail reports. I think we want it to be detailed reports with an ED.
All right, we'll include that in. Do we have a second for that amendment? Second for the monster amendment comes from Representative Weber. Okay, all those in favor of the amendment, please signify by saying aye. Aye. All those opposed, no. Okay, we're back on the bill.
Mr. Chairman, if I may, Representative Yin's last amendment, where do I need the ED?
So we have the printed out amendment that we got handed out for the on page 7, line 7, delete the word results and insert DETAILED.
Very good. Thank you. Thank you, Mr. Chairman. Representative Yin.
All right,
So, Mr. Chairman, the one question I would have is about the precinct versus ballot style question. So from my understanding, precincts could have several ballot styles because they do name rotation. So do we need to actually use ballot style instead of precinct?
I think we were leaving in the word precinct, but if you want to offer an amendment, we can do that.
Yeah, Mr. Chairman, just to be thorough, yeah, I won't strike precinct. We'll just insert ballot style after the word precinct on page 7, line 2.
Second. All right. All those in favor of the amendment, please signify by saying aye. All those opposed, no. Okay, that amendment carries.
Mr. Chairman, the only other thing that I would like to move is on page 4, line 4. This is, I mean, according to the secretary, it's more belt and suspenders, but I think it would be very clear to the clerk and helpful to deal with that 2-week timeline. So if we add unless authorized by the Secretary of State at the end of line 4.
All right, is there a second to that amendment? Okay, we do have a second. Representative Lucas. All those in favor of that amendment, please signify by saying aye. Aye. All opposed, no. Okay, thank you, Minority Leader Yin. To the question, we are voting on House Bill 278 as amended. Please pull the board. The committee.
Thank you, Mr. Chairman. Roll call vote on elections, voting machine, and voting system tests. Representative Brown.
Aye.
Representative Locke.
Aye.
Representative Heft.
Aye.
Representative Johnson.
Aye.
Representative Lucas.
Aye.
Representative Webb.
Aye.
Representative Weber.
Aye.
Representative Yin.
Aye.
Chairman Knapp.
Aye.
Mr. Chairman, we have 9 ayes.
With that, House Bill 278 does pass committee. This is our last day for getting bills through committee. And to the 2 bills that didn't get heard, which was House Bill 332 and House Bill 68, I offer my apologies for not making it through to complete the 4. That happens in session, of course. Many bills die from not getting into committee or dying on the floor in committee of the whole with the time frame. So I do apologize. Is there anything else to come before the board?
One of which is mine.
All right, with that, we are adjourned. You know what?